Andariki Shubhodaya. Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkar. This is a case relating to Bharatiya Nagarik Suraksha Samhita. Previously, we were trained, or we used to call it as the Code of Criminal Procedure. That was in 1973. Now this is 2023. Anyway, this is a case relating to the constitutional right of a person. Friends, you know, according to Article 22, Clause 2, according to Article 22 of the Constitution of India, if any person is arrested, he should be produced before the court within 24 hours. That is the constitutional limit. More than 24 hours, you cannot keep a person in custody. Of course, later you can take him to police custody, you can interrogate him, just like our Ibamma, Ravi and other cases presently going on. If the accused is produced after 24 hours, if the person arrested is produced after 24 hours, the arrest is vitiated. The arrest is illegal. The person has to be released. This is the basic law. But what happened is, so Kerala High Court reiterated that if the person is arrested and produced in the court after 24 hours, even after 1 hour, bail should be granted. Justice C.S. Diaz, in the case of Mohd.Nashif versus State of Kerala and State of Kerala and SHO Kozainimpara, PS, Palakkad District. This is a criminal miscellaneous petition 8946 by 2025, decided on 21/11/2025, in which the Honorable High Court of Kerala, Single Judge C.S. Diaz, held that the police cannot subvert the Constitution. Please remember, they cannot subvert. Downplay చేయడం లేదు. The constitutional right, the constitutional safeguards given to a person. Why? How? By rearresting the person. 24 hours దాటిందని వదిలేశారు, కానీ మళ్ళా పట్టుకొని కేసేసారు. సో పట్టుకోవచ్చా లేదా అనేటువంటిది ఇట్స్ అ టిపికల్ క్వశ్చన్. ఇట్స్ నాట్ దట్ ఈజీ. వీ కాంట్ సే ఇదేమీ స్ట్రైట్ జాకెట్ ఫార్ములా ఉండదు. ఎందుకంటే పోలీస్ ఆర్ ఎంపవర్డ్ టు అరెస్ట్ ఎనీ పర్సన్ ఎనీ నెంబర్ ఆఫ్ టైమ్స్ under 41 CRPC, presently 35 of the BNSS. ఒకసారి కేసులోకి వెళ్తే మనకి ఈజీగా అర్థమవుతుంది. రైట్, నో డౌట్ ఈయనేం పెద్ద మంచివాడు కాదు. ఎవరు? అవర్ Mohd.Nashif. Mohd.Nashif, he was arrested in crime number 525 by 2025 under section 22C and 29 of the Narcotic Drugs and Psychotropic section. So he and another person, they were found in possession of 338.16 grams of MMDA, which is a psychotropic substance. They were arrested on 27/2025 at 12:40 hours. On record మాట్లాడుతున్నాం కాబట్టి they have to be produced on 21/7/2025 before 12:40 hours. But they were produced in the court on 21/7/2025 at 14:10, that is 2:10 p.m. almost 1 hour 30 minutes later. That means beyond 24 hours prescribed period as per Article 22 Clause 2 of the Constitution of India. The magistrate somehow considered and he has remanded. Immediately the advocates on behalf of Mohd.Nashif, they approached the district court. District court held that yes, they have not explained the delay. అంటే జర్నీ టైం అని రాసుకుంటే పోయేది, రాయలేదు కాబట్టి వాట్ ఎవర్ ఇట్ ఈస్, ది అరెస్ట్ వాజ్ హెల్డ్ టు బి, ది ప్రొటెక్షన్ ఆఫ్ ది అక్యూజ్డ్ వాజ్ హెల్డ్ టు బి మోర్ దాన్ 24 hours. Therefore, the district judge immediately ordered his release. వదిలేయమన్నాడు జైలు నుంచి. ఓకే, వదిలేసాడు. ఇక్కడ మిస్టేకే మన తర్వాత వదిలేయమన్నాడు కానీ he has to be released on bail. ఆ మాట ఎక్కడ చెప్పలా. he should be released అన్నాడు, కోర్టు వారు రిలీజ్ చేశారు. కానీ పోలీసులు బయటే వెయిట్ చేశారు, మళ్ళా పట్టుకున్నారు, మళ్ళా ఆపరేశారు. Mahaprabhu, then he came to the High Court. So he says, On behalf of the accused, the advocate represents that the rearrest is illegal, rearrest is unjustifiable, and actually the district judge ought to have allowed him on bail. Unfortunately, with this, the district judge has ratified the illegal arrest. Right. So, they based on the case of Director of Enforcement versus Subhash 2025 case. ఎందుకంటే it was held that the arrest is void if the accused is produced after 24 hours. No doubt, here the judge asked his release, but police circumvented the law and they circumvented the constitutional safeguards also, and once again took him into custody. Right. Now, the argument on behalf of the state is that means PP, public prosecutor, he says, yes, as per 483 clause 3 of the Bharatiya Nagarik Suraksha Samhita, the police are empowered to arrest the person. Because of the provisions of 37, the rigor of 37 NDPS Act. That means the other part, the PP should have a say. PP గారిని అడగాలి దీంట్లో, దానికోసం వేశారు అన్నారు. సో he relied on the case law. Khatri అన్నారు, Khatri, KHATRI, Khatri and others versus State of Bihar 1981. But High Court said no. Illegal arrest can't be accepted. No doubt, there was a delay. The court identified. They have asked him to release. But how can you rearrest him? It is nothing but the subverting constitutional right of a person. He may be an accused. It is a different thing. You should have thought of the matters before producing before the court. మనందరికీ తెలిసిందే కదా, అందరికీ తెలిసిందే. ఇవాళ అరెస్ట్ చేస్తే వెంటనే పెడతారా? 2 or 3 days ఉంటుంది. అదేదో 24 hours చేస్తే పోయేది కదా. So immediately release him with, after he's furnishing a bond for 1 lakh rupees, వాళ్ళకి ఏమైనా 3 నిమిషాలు తీసుకొస్తారు, లేకపోతే FDR ఇస్తారు 1 lakh, and 2 sureties, and this person has to appear before the investigative officer on every Saturday, and vichitra, he shall not commit any similar crime. So this is one of the directions జడ్జి గారు రాశారు, మనం మాట్లాడకూడదు. కానీ వాడు ఆగుతాడా? నిన్నే చెప్పాను, 2016లో బెయిల్ మీద వచ్చి 2017లో he committed another murder. That may be possible, but anyway, good directions given by the High Court. So read the case law and enrich your legal knowledge. I am stopping here. Thank you very much.